Do I have the right to take mental health leave? Imagine this. You've been struggling with stress, anxiety, or depression. It's affecting your sleep, your focus, even your ability to get through the workday. You realize you need time off to recover, but you're scared. If you ask for leave, will your boss fire you? And most importantly, do you have the legal right to take mental health leave in the U.S.? This is a critical issue. Mental health is health, yet many workers feel unsure or ashamed to bring it up. Employers often act like only physical injuries count, but the law sees things differently. Under federal and state rules, mental health conditions can qualify for job-protected leave. In this video, we'll break it all down. What the Family and Medical Leave Act, FMLA, provides, how the Americans with Disabilities Act, ADA, applies, what state laws add, and what real workers have done when they needed time away for mental health. Mental health as a serious health condition. Under the FMLA, the Family and Medical Leave Act, FMLA, is the main federal law that provides job-protected leave. It allows eligible employees up to 12 weeks of unpaid leave per year for a serious health condition. That includes not only physical illnesses, but also mental health conditions. You qualify if you've worked for your employer for at least 12 months. You've logged at least 1,250 hours in the past year. Your employer has 50 or more employees within a 75-mile radius. Mental health conditions like major depression, anxiety disorders, bipolar disorder, or PTSD can qualify if they require ongoing treatment, counseling, or cause periods of incapacity. Example: an office worker diagnosed with severe depression is unable to work for several weeks. Her doctor provides certification, and she takes FMLA leave. The employer must hold her job or an equivalent one when she returns. What FMLA leave covers for mental health? Under the FMLA, mental health leave can cover extended time off to receive treatment or stabilize, intermittent leave for therapy sessions, counseling, or medication adjustments, time off during flare-ups that make working impossible. Employers cannot retaliate against workers for taking FMLA leave. Health insurance benefits must also continue during the leave. Example: a worker with PTSD takes intermittent leave for weekly therapy appointments. His employer must allow it and cannot punish him for absences covered by FMLA, the ADA, and reasonable accommodations. The Americans with Disabilities Act, ADA, also protects workers with mental health conditions. The ADA applies to employers with 15 or more employees and requires them to provide reasonable accommodations for disabilities. A mental health condition counts as a disability if it substantially limits major life activities like sleeping, concentrating, or working. Reasonable accommodations can include flexible schedules, reduced hours, work-from-home arrangements, short-term or extended leave. Example: a retail worker with anxiety disorder asks for reduced shifts temporarily. Denying that request without considering alternatives could violate the ADA. Importantly, the ADA doesn't guarantee paid leave, but it requires employers to consider leave as a form of accommodation. Difference between FMLA and ADA. Leave. FMLA. Leave is specific. 12 weeks of unpaid, job-protected leave if eligibility is met. Documentation is usually required. ADA leave is more flexible. It doesn't set a time limit but requires case-by-case analysis. Employers must show that granting leave would cause undue hardship if they want to deny it. Together, these laws cover many situations where mental health leave is necessary. State laws. Expanding mental health leave. Some states go beyond federal law by offering paid leave or lower eligibility thresholds. California. Workers can use paid sick days for mental health conditions. The state also provides paid family leave benefits for caring for relatives with serious health issues. New York. Paid sick leave laws explicitly cover mental as well as physical health. Some, New Jersey and Washington. Paid family leave includes bonding time with a new child and caring for relatives, but can also overlap with serious mental health conditions. Oregon requires employers to provide sick time that can be used for mental health. Example, a part-time worker in New York takes 2 days off for acute anxiety. State law requires the employer to provide paid sick leave. Employer excuses versus legal reality. Employers sometimes try to deny mental health leave, claiming, "We don't cover stress or anxiety. You haven't been here long enough. We don't have enough staff. Mental health doesn't count." But legally, stress and anxiety can qualify if they're serious and medically certified. Eligibility depends on law, not employer preference. Staffing shortages don't override federal rights. Mental health is recognized equally with physical health under FMLA and ADA. Example, a call center worker requests leave for depression. The employer says, "We only grant FMLA for physical conditions." That's unlawful, retaliation and wrongful termination. It's illegal for employers to fire, demote, or harass workers for requesting or taking mental health leave under federal or state law. Retaliation claims are among the most common workplace lawsuits. Example, a worker is approved for intermittent FMLA leave, but later fired for attendance issues tied to those days. That's retaliation and a violation of federal law. Real-world cases. Case 1. A hospital employee took leave for depression. The employer terminated her, claiming poor attendance. The court found this violated the FMLA because absences were protected. Case 2. A retail worker with bipolar disorder requested reduced hours. The employer refused and fired him. The EEOC sued under the ADA. Case 3. In California, a worker used paid sick days for therapy. When denied pay, the state labor commissioner ordered reimbursement. CMMS. Case 4. A New Jersey employee was terminated after taking leave to care for a child with mental health issues. The state's family leave protections applied, and the employer faced penalties. These cases show courts take mental health leave seriously. What workers can do if denied leave. If your employer denies mental health leave, 1. Check eligibility. Confirm FMLA and ADA coverage. 2. Get medical certification. Documentation strengthens your case. 3. Request in writing. Always submit leave requests formally. 4. File a complaint. The Department of Labor enforces FMLA. The EEOC enforces ADA. 5. Document retaliation. Keep records of any negative treatment after requesting leave. 6. Seek legal advice. Employment attorneys often take FMLA and ADA retaliation cases. Example, an office worker denied leave for anxiety files with the Department of Labor. Investigators order the employer to reinstate his job with back pay. The bigger picture. Mental health leave highlights a cultural shift, recognizing that psychological health is as important as physical health. Federal and state laws are catching up, giving workers real tools to protect themselves, but many employers still resist. Workers who know their rights under FMLA, ADA, and state sick leave laws can push back against stigma and unlawful denials. So, do you have the right to take mental health leave? The answer is yes, in many cases. The FMLA gives eligible workers up to 12 weeks of job-protected leave. The ADA requires reasonable accommodations, which may include time off. State laws often add paid sick days that cover mental health. Employers who deny leave or retaliate risk lawsuits, penalties, and government enforcement. The bottom line, mental health counts. If you need time away, don't assume you're powerless. Document your condition, know your rights, and demand fair treatment. If this video clarified things, share it with coworkers. The more workers understand mental health protections, the harder it is for employers to ignore the law.